The next case is State versus Jackson. Looks like we're right about on time, Mr. Chairman. Are you ready to proceed?
Thank you, Your Honor.
Yes. And the state has waived their appearance at oral argument that we're arguing this morning, so you have 15 minutes.
Thank you very much, Your Honor. Please, the court, as the court knows, we have various issues relating to both ineffective assistance of counsel and prosecutorial misconduct, and they dovetail together somewhat. During the direct examination, or redirect examination of one of the state's witnesses, Detective Swanson in this case, by the prosecuting attorney, the prosecuting attorney asked Detective Swanson a question: is it relevant to this defendant's innocence as to whether or not he's guilty who a 19-year-old woman had voluntarily engaged in sexual intercourse with? Answer by the witness: it is not. The next question was, is it an attempt to smear her character, and at that point, defense counsel objected. Initially, the court overruled the objection. Then there was a sidebar discussion, and after that, the court gave an instruction in disregard, a curative instruction. It is very correctly indicated by the state in its reply brief. The court, at a couple of times, well, the court in its instructions first did, again, per usual in instructions, tell the jury anything that's been stricken, disregard that, and also the evidence is what the jurors properly heard that was not stricken by the court. So we certainly agree that the court did strike the remarks, and then during instructions twice more refer to the facts. Don't consider nothing that was stricken should be considered. However, we respectfully submit to the court that this is one of those statements that's so inappropriate, so improper, that it can't be cured by a curative instruction. And the court.
So you're not really objecting to the fact that you thought that line of questioning was improper. It's just a matter of, in other words, the prosecutor says, is that relevant? That's not really what you're upset about.
Oh no, it's the smear
piece.
That's just what led up to it.
So the testimony that was introduced, in your mind, wasn't relevant. If somebody had sex with somebody at one time, doesn't mean they agreed to it the next time. Obviously, we all know that, right?
Yes, Your Honor.
Okay, so so it was just a matter of the prosecutor saying, obviously, that was just meant to smear.
And in fact, yes, and that's the part we're objecting to. Certainly, in the context of this case, it's not so much who, I'm going to abbreviate and call the alleged victim CJ in this case, being the person who's minor during part of this.
I appreciate that.
Thank you, Your Honor. But certainly during some point, let me rephrase it, Your Honor, the precise identity of who she did have sexual relationships with may not be so relevant, but the fact is that the evidence in this case was that there were two other individuals with whom CJ had sexual relationships with very closely to the time that she alleged in count 4 of the indictment that she had been digitally penetrated by the defendant. That's why it's relevant here. It's certainly, you know, I submit that the evidence shows it was not an attempt to smear at all. It was an attempt to bring out that there were other individuals that, in fact, had not even been disclosed by CJ, either to the investigating healthcare professionals, nor to Detective Swanson, who testified on cross-examination that he hadn't been told by CJ that she had sexual relationships with other individuals right about the same time as the alleged conduct in count 4, for which the defendant was convicted.
Are we going to find, counsel, in the record with regard to the detective's interview of CJ that anyone asked her whether she had sex with anyone else. Because, you know, it seems to me that that's really relevant. If on the one hand, the detective says, okay, well, you're going to do this DNA test, and, you know, you're saying that this happened with your father. Were you sexually active with anyone else in the same time? And she says no. This becomes more relevant. If no one asks and she didn't tell, then it's another issue.
Well, I understand what the court's saying. I guess you can look at it both ways. What's clear, all I can say from a review of the record, what's clear, not having tried the case, what's clear from the record, as I best understand it, is that Detective Swanson did testify that that information had not been reported to him. Now, that's something that should have been reported, certainly. That we know what questions get asked during a rape protocol and with a rape kit, and those are normal questions.
You know, we could know a lot of things, but
yes.
The issue is what's in the record.
Well, what's in the record is that she didn't tell Detective Swanson.
She didn't tell him, but my question is, did he ask her?
I don't know, Your Honor. Okay. Don't know the answer to that. The fact is, my position, however, is that the fact is that she didn't report that. So that is something I think that is appropriate to go into by defense counsel based on the fact that it hadn't been reported. It certainly was, I think, part of a normal defense task, but you know what was reported, and that was certainly relevant information. And so for prosecutors to say that is it an attempt to smear her character, that is such a personal attack on the defense attorney that I submit that's the type of thing that can undermine a jury's belief at all or belief in the credibility of that individual.
2 points, if you don't care.
Yes,
one is, I apologize for my prior question because I completely misread something in your brief, so I
yes,
apologize. So I didn't even lead you off on a wild goose chase there. Number 2, though, if this comment, I guess I'm characterizing the comment, but it's technically was a question, but I understand your point. If this were made during closing argument, would it be reversible error? Because that's the kind of thing that usually you see, well, I've heard this testimony, this was just an attempt, blah, blah, blah.
I appreciate the court's question. I would respectfully submit it's improper whenever it's improper in either context. It's particularly improper when asking, and it's a little different context when asking a witness. I submit it's even worse with a witness because here's Detective Swanson, a person of authority, being asked by the prosecutor to characterize what the defense attorney is trying to do. I mean, there's no rational or reasonable reason for the prosecuting attorney to have asked that question except to, frankly, taint or poison the jury toward both the defendant and his attorney and both of their credibility. And
was there anything that the court could have done in your mind looking at this record? Well, first of all, are we going to see that that defense counsel asked the trial court to say something else?
I'd love to answer that question, Your Honor. This reminds me of the case that I cited in my brief, State versus McCarley, and I tried that case, and I remember it well. In McCarley, the court, there was a witness for the state who was a psychologist who was getting off the witness stand, and the judge said, "Thank you for coming in today. We appreciate your coming in. We all know your reputation, your good reputation in the community, and hope you get your license back soon." She had had a suspended psychologist license at this particular individual. Defense counsel, it was me, objected and asked for a mistrial. The court offered in McCarley, we'll just give a curative instruction, and our position in that case was no, a curative instruction will not cure that. This is so bad, it's the court vouching for the witness's credibility. And in fact, this court reversed the conviction based upon that some things can't be cured by, so to answer your question, Your Honor, I can't think of any other curative instruction. This was just really, I submit, misconduct by the prosecuting attorney. It was really out of line.
Right. It's a little different, I suspect, than to have that can happen kind of in the heat of, you know, than to have the trial judge to say that about a witness. Although I'm sure that will lead you into the discussion about the trial court saying something about he's trying to answer honestly.
Same type of thing.
Okay.
And in terms of the heat of trial, again, we don't know what's in anyone's mind, in the prosecutor's mind when that question was asked, but as lawyers we're expected to think about the questions we ask before we ask them, and they're supposed to be appropriate. And again, I submit based on the evidence, based on the context, this is completely improper.
Well, then we have to also look at, what the impact is given the evidence. If the evidence is overwhelming, is there prejudice?
I'd be happy to address that too, Your Honor. First, there's other prosecutorial misconduct as well, which I'll address, but to answer the court.
Counsel, can I just stop you just for one
Yes,
second?
ma'am.
How much time, if any, did you want to, oh, you don't have to reserve. Never mind. Well, I'm telling you, I need more sleep last night. Go ahead.
I follow you, Your Honor. In any event, there is other prosecutorial misconduct as well, and which I'll get to, but concerning the prosecutorial misconduct as a whole, when compared to the evidence in this case, as the court knows, and we addressed manifest weight, which I'm not going into at this point, but the evidence was primarily, I don't want to mischaracterize it, but it was testimony by CJ. Certainly there was other evidence in the case. There was testimony by her sister, testimony by the medical professionals, etc. But there was a tape played of the defendant on a controlled telephone call. Certainly there was other evidence, but in the realm of how strong it is from overwhelming to evidence at all, I submit that this was not the strongest evidence in the case. And that is exemplified, I submit, by the fact that the jury did acquit on one count and they were hung on another count, which the state subsequently dismissed. This was not, I submit, the strongest of evidence to answer the court's question.
Well, that goes to, I think, the fact that the jury was really paying attention and could sort out where there was a lack of evidence and where there was guilt beyond a reasonable doubt.
I generally would agree with that. However, in this case, I think that the things that came in improperly, either through actions by defense counsel or actions by the court or the prosecuting attorney, made the convictions much more likely to have occurred, and I submit did affect the result in this case, because I'm looking at the 2 counts for which there were convictions, and I would submit that those very likely would not have occurred but for the conduct both by the prosecuting attorney and again, also by defense counsel.
Well, I'm thinking about the admission of your client that, yes, I did offer her alcohol, and yes, we did, she was there on the day that she said that this happened, and and then the telephone call where she's basically, he's confronted with, I'm uncomfortable with this inappropriate touching. And he doesn't say, what are you talking about? He says, well, we need to stop drinking when we're together.
And we wouldn't do some things we did if we weren't drinking.
Yeah, that's a real problem.
That is certainly evidence that favors the state. I won't disagree with that, but it's not, I submit, to the level of an adoptive admission by not responding or that type of thing. He did not, in fact, admit the allegations. So, although certainly those statements were evidence that were state-oriented as opposed to defense-oriented in terms of a controlled call. I agree with that, but again, there was not an actual admission to anything, and I would ask that be taken in the context and the consideration with the evidence as a whole, including the defense-oriented evidence in this case. During closing argument by the defense attorney, I guess I've got about 2 minutes left, maybe, Your Honor?
You
or less.
have actually a lot less, but I'm going to give you an extra minute because I led you off on a wild goose chase. So.
You did not, Your Honor. Thank
Go
you.
ahead.
In the closing arguments by defense counsel made 2 remarks which were objected to by the state, and the objections were granted, and those were to the defense counsel mischaracterizing the weight to be given respectively to direct versus circumstantial evidence, and also some statements in effect, put yourself in the defendant's seat, or somebody you love, somebody you care about, a son, a family member, etc. That was objected to and sustained. And that was very shortly, within probably 20 lines or so in the transcript, before the defense attorney sat down and finished his final argument to the jury. Not only were those statements made by the defendant, they're pretty basic things that were misstated by defense counsel, and again, that weighs on the credibility of the attorney, which reflects on the credibility of the defendant, and again, both those things are right near the end of the final argument. Those are times where it just basically takes a lot of the effectiveness out of the final argument. But then the prosecutor, without objection by the defense attorney, after the court had already overruled or granted the objections by the state and stricken these remarks by the defense attorney, got up in his closing argument and said, so what the defense attorney, what he told you about the law is completely incorrect and not accurate and will be inconsistent with the law that Judge Davis gave you. I submit that is in effect, as we say in football, piling on. It was unnecessary. The court had already told the jury to disregard those things. I submit that it goes beyond appropriate argument. It was, again, an attack on defense counsel's credibility. It was out of line. And I submit it should have been objected to, or some action should have been taken by defense counsel.
And you are out on that.
Thank you very much, Your Honor.
Thank you very much, too. Thank you for your argument to the court this morning. The court will take the matter under advisement and send a copy of our decision to you as well as the state.
Thank you, Your Honor.
On our website, too. Okay, thank you. Have a good day as well.